Bail, the temporary release of an accused person whilst awaiting trial. This process is under review. Some may say it's under fire. Is there a problem with the present bail procedures? Should there be an amendment? If so, what should those amendments be? If passed, will amendments reduce the rate of crime? Who knows? These issues and many more will be discussed on the next Legal Brief. I'm your host, Ramona Farquharson, and you're watching ZNS TV 13. Bail, oh bail, a very timely topic as many Bahamians are discussing this issue. Our political leaders are seeking to formulate strategies to tackle our present crisis as the rate of crime increases. In fact, some would say it's out of control. On this episode of the Legal Brief, we will seek to educate you as to what is bail, what is the process, what is the present status of bail, what are the proposed amendments, and at the end of the day, we will leave it to you to decide whether you agree with the proposed amendments and whether you think that the strategy is workable or not. To assist me with this task, once again, would be Ms. Darnell Dorset, Assistant Director of Public Prosecutions Acting, and Mr. Stanley Roll, Chief Officer of the Public Defender's Office. Welcome.
Thank you.
Thank you.
Pleasant to be here.
Didn't expect to have you back so soon.
Yeah.
We had a wonderful time discussing appeals, but we're back again because, of course, this is really the hot button topic. Surprisingly, everybody wants to know about bail. So let's start off. What is bail? What is bail?
Well, bail is a set of pretrial restrictions imposed upon a defendant with the intention that that defendant appears for his trial, keeps the peace. By that I mean that he does not allegedly offend or commit offenses while on bail. And basically, I keep saying he, but the defendant does not interfere with the course of justice.
Okay, so that our listening audience understands. Once you are arrested and charged by the police, placed before the courts, you don't have the right to just walk out. No. So the courts impose bail, meaning there's certain conditions that you have to agree to, sign on to in order to have your liberty. And so just putting that in context, I want us now to focus on, because you can get bail for a plethora of offenses. Because sometimes people can be released on their own recognizance. That is too a type of bail, but you release on your own recognizance. But let's look now at when persons are charged with Part C offenses.
Yes.
Go ahead.
The offenses would include murder, attempted murder, possession of a firearm with intent to endanger life, some sexual offenses, and so very serious offenses, the most serious.
In our what we consider in a society. Yes.
Yes, the most serious in our penal code.
Armed robberies.
Yes, armed robberies as well.
And so here it is. Once you're charged with these Part C offenses, the magistrate does not have the power to grant bail.
Yes.
You must then go to the Supreme Court.
Yes.
So if you can, either one of you elaborate. What is the process? I'm now before the Supreme Court, charged with one of these offenses, Part C offenses. What do I do in order to go before the courts to be considered for bail?
Well, for a represented defendant, the counsel for that defendant would draft up what we call an affidavit and a summons the summons moves the court in terms of the date of the hearing. Then the affidavit, actually within the affidavit, the former Chief Justice Michael Barnett, he issued a practice direction number 1 of 2013.
Yes.
And in relation to a magistrate's court application for bail, it ought to have the date of birth of the applicant, the national insurance number of the applicant, any other names by which the applicant is known,
AKA.
AKAs, a copy of the charge sheet as an exhibit, or the docket number and charges in the magistrate's court where the bail is being sought for that person, and confirmation as to whether there are any other charges that are pending against that particular defendant. And in the Supreme Court, it's basically the same,
Yes.
but it's basically the same
Yes.
in both
Magistrates and the Supreme Court.
Yes, yes. For unrepresented defendants, however, usually they make their applications on their feet when they are arraigned before a Supreme Court judge. And then they are remanded, and the Supreme Court judge, at that time, when they request for bail to be considered on their own behalf, given the fact that they do not have counsel, then the judge will set a date for the hearing of the matter. My office, the Office of the Director of Public Prosecutions, has the duty to then answer
Put in an affidavit in response.
Yes, an affidavit in response. What is our position, whether or not we are objecting, or if we're not objecting. If we're not objecting, obviously there would not be an affidavit in response. We just say we're not objecting. However, if we are objecting, then
You
we are
state your
duty bound,
reasons.
yes, to state the reasons in an affidavit in response.
Right. You agree with that, Mr. Rule?
I do. In the practical world,
You smart.
the defendant would say, they fight me down.
Oh, okay.
Yeah. But with respect to the application itself, you could make the application right away. Generally, some people believe, oh, I'm going to wait till I get my VBI. You don't have to wait.
And when we say VBI, we're talking about the voluntary bill of indictment.
Yes, before the Supreme Court,
Before the Supreme
which brings the because once a person is arraigned, say a first plea in relation to the offense before the magistrate's court, the matter, in order for it to be transferred to the Supreme Court, a voluntary bill of indictment has to be prepared for by counsel in my office, and then it has to be presented before a Supreme Court judge within
Signed
14
and
days.
properly laid.
Yes, signed by the Director of Public Prosecutions.
Yes.
Yes, or whoever is sitting in that chair.
Yes.
Yeah.
And then yes, go ahead.
I would say once the summons and affidavit is prepared, it's filed, it's taken to the criminal registry, and then you get your date for the hearing.
Yes.
In the meantime, the Crown is served. If they're going to fight you down, then they will give their response.
I don't know if I really like that term, fight you down, because we are ministers of justice
But that's the word that's
on the street.
the common vernacular. Yeah.
They would respond, and then it gives you an opportunity. If you disagree with what they say, you reply to their assertions. Because you find sometimes if you are a person with pending matters or purported convictions, not everything that comes on that paper, on what we call the antecedent form, connects you or is related to you. And my learned friend would say, sometimes the police do make mistakes.
I'm going to stop you right there. We're certainly diving in. This is going to be very, very interesting. When we return, you're watching The Legal Brief.
Health officials announced early on that the curve of the court case.
And cue.
At a fire had erupted in Atlanta.
All of the victims have lost their lives.
My learned friends, we're just discussing the bail process. And so we know the summons, the affidavit, they've been filed, particularly for those who have counsels, as you've outlined, Ms. Dorset. And I have to put in a plug here. If you find yourself charged with Part C offenses, I would urge all people, please get counsel. Whether it's private counsel, we would say independent counsel, or counsel from the public defender's office. please find counsel because they're very serious offenses not to be taken lightly. I mean, the sentences are quite stringent. So back now to the bail process. Summons affidavit has been filed. You've served the Attorney General's office. Now you have your date. What happens next?
Well, I'll start because the applicant, who is the defendant, would present his case. In most cases, you tend to go through the summons. Speaking for myself, if it's pretty straightforward, I tend to just commend the affidavit to the court, and
You don't do much pleading.
no.
You don't do much pleading.
It
Okay.
depends on how you write. You have to write it in a way that when the court reads it, the court understands it without question. Then she would respond. And then when she's finished speaking, then I'm going to say what we do.
Okay. Go ahead.
The considerations.
Yes,
in
the
terms
considerations for bail.
of response on behalf of
Yes.
my office, and also that in terms of what the court would take into consideration, reference to the applicant, the bail applicant, is whether the bail applicant will surrender to custody or appear for his trial. That's the most important thing. Whether or not the bail applicant bail is really not to limit the liberty of the subject or the liberty of the citizen, but actually to make sure that he or she appears for their trial. That's the most important.
I think people really, that really requires emphasis.
Yes.
Because so much is being said about bail, but
Yes.
really that's all, predominantly that's what it's about.
That's all the court is concerned really about. Is with this applicant, if I was to grant bail, meaning a judge, appear for his or her trial.
Having regard to the offense that they've been charged
Yes,
with.
having regard to
I
the
want to
offense.
make sure that the process will not be hindered.
Yes, and also having regard to the constitutional rights of the
Yes.
applicant. Article 19 of the Constitution, which says that a citizen should be tried within a reasonable time.
Yes.
Within a reasonable time, according to the Bail Amendment Act 2011, is 3 years.
3 years.
Yes, and also Article 20 speaks about the presumption of innocence. I believe the Attorney General, Mr. Ryan Bittner, has spoken about that, and also the Minister of National Security, Mr. Wayne Monroe. They have spoken about that, but I don't want to
presumption
get ahead
of-
of ourselves in relation to this new amendment 2024.
Right. Let's
Amendment
talk
Act.
now, let's look now at what the status quo is.
Yes.
Yes.
Yes. So the status quo is one, whether the court will be concerned whether or not the applicant will fail to surrender to custody or appear for the trial. 2, commit an offense while on bail. 3, interfere with witnesses or obstruct the course of justice. 4, the strength and seriousness of the offenses for which the applicant is tried, or on the seriousness or nature of the evidence that we, meaning the Office of the Director of Public Prosecutions, has against the applicant.
Meaning if there's perhaps DNA evidence or
DNA evidence,
eyewitness,
evidence,
some
strong
cogent,
evidence,
yes.
cogent evidence.
Not confession.
Yes. Well,
They
confessions-
smile because, yeah.
confessions, but just with other evidence.
Yes.
Actual evidence. Yes, the court looks at all of that because bail is an informal exercise, meaning that the prosecution has a right or a duty to inform the court whether or not, say, for instance, the bail applicant was wanted by the police. That happened in the case of Bradley Ferguson and others,
Yes.
where Justice Osadabe said the prosecution was duty bound to actually inform the court that
Officers of the court, yeah.
that this person was wanted by the police for over a year, and they just found him, and he was reduced into custody and brought before court.
That calls into question the paramount consideration.
Yes.
Will you surrender?
Yes, will you
Once I
surrender?
give you bail, I cut you loose. You're
Yes.
gone until I
Yes.
get you again.
Yes, that's
And
right.
so certainly not a position that the court wants to find themselves. Are there any other considerations?
Yes, other considerations, according to the Bail Amendment Act 2011, is whether the defendant should be kept in custody for his own protection,
Interesting.
or where he is a child or young person for his own welfare. And as we know now,
Yeah.
we have had 17 to 18 murders, actually, or 17 murders in the Bahamas so far, recorded unfortunately and sadly. And we give condolences to those families, and we empathize with them as well.
But we're
But
hearing
we,
more and more people are saying that those who are on bail
yes,
are in fact losing their
yes,
lives.
they're at risk.
They're at
I believe
risk.
the Minister of National Security, Mr. William Monroe, may have said about 48% of the persons who died, who were killed by by firearms last year, were those persons who were granted bail. They weren't bail for murder. And so it is a serious risk. Now I have up in my office um, a newspaper clipping where a young man recently turned himself into the court. I believe it was Justice McKay's court to say, "Judge, take me in, because if you don't take me in, I'm a dead man."
Wow.
And so it has gotten to that extent.
We're in perilous
Yes,
times.
yes, that we are in perilous.
And so we can certainly understand why certain strategies, and we're
Yes.
going to come to discuss those.
Yes.
But are there any further considerations?
Yes. Another consideration is whether the applicant is in custody in pursuance of the sentence of a court or any authority acting under the Defense Act, whether there is sufficient information for the purpose of taking the decisions required by this part or otherwise by this act, whether having been released on bail in or in connection with the proceedings for the offense, he is arrested pursuant to Section 12. Whether having been released on bail previously, he is charged subsequently either with an offense similar to that in respect of which he was so released, or with an offense which is punishable by a term of imprisonment exceeding 1 year.
And so it's interesting how the amendments of 2011
yes,
have really, I would think, very thoroughly addressed considerations of bail. But again, we'll come to what's being proposed for 2024.
yes,
But I think those considerations are quite detailed there.
yes, yes, they are.
Yes.
Well,
Mhm.
it is then the task of the defense attorney to show the flip of whatever it is that the respondent, the DPP, asserts in the affidavit. If I accept 48% of those murdered were out on bail, how I deal with that is we look at the many number of persons charged with murder out on bail, and you compare that percentage with those, that may only be 2% in reality. So the murders, that 48%, in my view, it just fits into a small section of persons out on bail. If we've had, I'm sure the prosecution has not closed every trial for murder in the past 5 years. We just have 17 in 1 year. If there are 100 persons out on murder, you see the difference, that's about 70 somewhat left, 73 persons. So you see the 48%, it may look big, but in reality, it's...
When you take it in context.
Yeah, and
In
so
context.
in my reply, having commended the affidavit, hearing them, everything that they say, we have to fight down.
Okay,
Defense
we're back
has-
to this theme.
has to fight down.
Mr. Rosen,
But
you
I
gotta
would just
fight
say-
it down.
But the reason why you do it is because you want to make what she say and what I say balance, and then leave it to the court to look at whether or not, to look at my character, to look at whether I've been on bail before and how I've dealt with my bail conditions.
Certainly, so that the court can make a real informed
A
decision.
judicial decision.
Yes. So in essence, you put forth your application, you listen to the response by the
DPP's office.
DPP's office, and then you come back with your reply.
My rebuttal.
Yes.
Yeah.
Yes.
Rebuttal.
Yes.
There you go. I mean, Mr. Roll, you are just, you're ready to go. You're ready to fight it down.
Yeah, you have to.
When we come back, we're going to be looking now at proposed amendments. And that's really what's brought us here so quickly, for us to look at what's being proposed and whether or not it makes sense. Is it really going to bring about the solutions that our legislature is looking for? You're watching The Legal Brief.
I'm Kim, an all-around busy person, but I'm also a foodie. Bahamian food is a delightful fusion of flavors and techniques passed down and over time has evolved into unique and delicious meals. It takes simple ingredients and it turns into something special. So if you're a foodie like me and don't like spending all day in the kitchen, but want great food, fast, simple, and tasty, then join me as we dish it up.
Welcome back. You're watching The Legal Brief. And on this episode, we're discussing bail, bail, bail. Oh, bail. Just before the break, one of the conditions that you had highlighted had to do with if there's been a breach of Section 12.
Yes.
And so just for our listening audience, for them to know, Section 12 just deals with if there's been any breaches in terms of absconding or breaking any other condition.
Yes.
So just so that's clear, people listening and be like, well, what's Section 12?
Okay.
Well, we move from the amendment of 2011 and we then look at the substantive act.
Yes.
But we're now coming to the bill for an act to amend the Bail Act of 2024. And so these are proposed amendments to the Bail Act. And so one would think that they will either repeal the amendments of 2011 or add to it. I don't know how, but we'll see. But let's dive straight in. And so what are the proposed amendments? People are talking about it. Break it down for us.
Well, one of the first things that came to my attention is Section 9A, subsection 3, which reads, the breach of any of the conditions contained in the recognizance of bail shall result in the revocation of bail.
Why is that important?
But currently, what happens is after there is a complaint of a breach, it is the prosecution, the respondent, who then becomes the applicant, who moves the court to revoke your bail. What the amendment does is we don't need the DPP anymore. By itself, if I breach bail, it's an automatic revocation of my bail.
How would that become known to the court?
What the legislation provides is one of two things. There's a system in place now where the police, through the monitoring of persons that are being monitored, and if I understand it, it may only affect, if you look at it, persons who are being monitored.
The ankle monitor.
Yeah.
So if you're failing to charge the battery, or
if I have
interfering with the
or you're somewhere where you ought not to be, or
at a certain time.
If you have a curfew or time you're to whatever, if let's say there's been a curfew placed upon you.
Yes.
I know I've been in court where certain justices will say, well, do you work? Well, what are your shifts? Well, I want you home. If you get off at 6, I want you home by 8 p.m.
Also,
or on this particular area.
Signing
signing in
condition.
station.
Yeah.
The police station would refer that matter to us.
So you're saying the present status, the status quo is if there have been breaches, that the Crown,
Yes, the DPP's office.
the DPP's office would be the ones to put in an application for revocation.
Yes.
And of course, you would then be able to explain yourself and explain, okay, I didn't charge the battery for this reason, or it's wrong,
Or it's faulty.
faulty, I was there, whatever the case may be, you can then answer. But under this amendment, say again, how is this different for us?
Well, the DPP don't need to do anything. I think what is necessary or what might be missing.
So who can make that? Is it then, I'm reading it, I don't know if it's abundantly clear, but I take it then,
Yes,
a call can then come from the police, from someone who I guess is in charge of the police station, and say, well, okay, this person,
Signing in.
John Doe has not signed in for the past month. They used to have a machine. I don't know if you recall, you see it in the stations.
Yes.
Where you go in.
Yes.
and
sign in.
and you
Okay,
sign
yes.
in.
Yes.
However, I think a
Long
lot of
time
them
media was
are
in charge of dealing
not
with the machine.
working.
Yes.
And so people have now, unfortunately, you're back now to the pen and
Signing in.
paper signing in with the ink. So that's a bit unfortunate. because there was so much talk about that and how that was going to revolutionize and make it easier
Yes.
on the stations with these machines.
Mhm.
And I see them there, and they're, they're not working, and they're just taking up room.
But in a lot of cases, I think some of the applicants who were granted bail did not have any identification
Right.
or passports or that kind of thing that the machine probably required. And so
Oh.
that,
Or maybe my friend might have signed me in.
I don't know. I don't know.
Mr. Eamon Poitier.
It happened.
But I believe in the past, whether it says the breach of any of the conditions contained in the recognizance of bail shall result in the revocation of bail. I believe in the past the magistrate or the judge had a discretion. It may have been may.
May.
Yes.
But now
So
it's
now
shall.
shall is mandatory, meaning that
And so that's why to
they have no
me,
discretion. The discretion has been taken away.
it's so important for me, and hopefully the powers that be, they will view this before certain debates.
Yeah.
It needs to be more tidy. Who would be making the allegation? Because again, it's an allegation, isn't it?
From the police.
It would be an allegation
Yes.
that the defendant is not meeting the conditions. And not just the police, but those who have charge of the ankle monitor system. I don't believe that they are. They may have been former police officers, but
Yeah.
I believe it's private companies.
Yes.
And so oftentimes a lot of these things are politicized.
Mhm.
Who's running the project from, it changes, it seems as if from election to election for whatever reason. We don't get into that. But I think for me, that's cause for concern.
Yes, and we also have to take into account the other stakeholders, which is members of the community.
Yes.
Those members also would inform our office whether or not their family member is signing in or their boyfriend.
Well, if
or-
they're a shorter,
yes,
one would
they
think that they have the right to go straight to the courts.
Yes,
And say, well, I wish to
sometimes they
withdraw.
they
The
report the matter to us,
amendment,
Okay.
to our office.
the amendment allows for me, I sign your bill, and I believe you may not show up, or I believe you're doing what you ought not to be doing. It provides for me to just write a note to the police
And inform the police.
and inform the police, and you will be arrested and brought before the court.
No.
That is what the amendment provides.
And see, and so then
What it does do,
I can see a lot of things can go wrong and awry.
but
I believe when you're talking about, just for me, you're taking away somewhat, because if you've been granted bail, the courts have exercised their discretion. They have reviewed all of the circumstances, and a competent court, a Supreme Court, has said, "I will grant you bail." And here it is now. We're saying that it can just be taken away, and I don't like, so to speak, the lack of formality and how that can be done.
well, I think the spirit of the intended of the bill is to make persons more accountable, make them more responsible, particularly the suretors, because the suretors in this under 9.5, the suretors play a role in my view, in supervising and ensuring that I come to court, that I don't commit offenses while on bail, that I don't interfere with witnesses. It makes the suretors really consider, am I truly of the view that this person will do certain things? So if I take the view that, boy, knowing him, he can go away with, I'm not going to sign the bail. So what happens? He stays in jail. And many suretors take a certain view. Many persons will not be admitted to bail. I mean, they will have bail, but they will not be released because the bond is not executed. So me as the defendant out on bail, because if you breach the peace, what it says, that the accused person not commit any offenses while on bail. So the police may charge me. I'm not convicted. The police may charge me, but an obligation under my condition is that I not commit any offenses.
So is
I can be brought before the court.
what's up this issue, but
Can
saying
you
not
talk about what the
commit?
conditions are?
Yes.
The-
yes.
What this act, what this amendment to the bill, it says the Bail Amendment Act, Bill 2024, because it has not been debated before Parliament
Yes.
as yet, or the Senate. so it has not been passed into laws yet. But what is interesting and significant too is the proposed section 9(6). If you go to that, it states that the recognizance of bail may be conditioned: A, that the accused person reports to police station or other designated place at the time specified therein. B, that the accused person is monitored by an electronic device. C, that the accused person surrenders his passport or other travel documents. D, that the accused person keeps the peace and be of good behavior. Or E, that the accused person be subject to such other conditions as prescribed by any practice direction issued by the Chief Justice. Now, this is the first time that any bail act in the Bahamas has outlined the conditions of bail.
Yes.
This is the first time. And so it goes down to section 12A, which is 4. It says, offense of violating conditions of bail. Any person released on bail in criminal proceedings who breaches any conditions of bail commits an offense.
And-
So any of these conditions that has been outlined in this
Yeah.
new Bail Amendment Act and you breach it,
It's an
then
offense.
then it's an offense and your bail will be revoked.
And
So it's more onerous on behalf
And
of the
that's,
defendants.
and that's where this word shall
Yes,
comes into play.
mandatory, which is
Now,
mandatory.
again. So is it then that the judge then has no discretion,
If a magistrate,
but, sorry?
probably if the magistrate,
Yes, the magistrate will not have a discretion
No,
because
the
the
magistrate would not.
statutes, yeah.
So you're saying then, because too, I want us to look at Part C offenses.
Yes,
And we're talking about being before the Supreme Court.
yes.
So again, because let's touch it. This is what people are upset about and are discussing. They're saying persons are on bail for murder, armed robbery, whatever, very serious offenses that fall under Part C. And here it is. In their minds, they're being allowed on bail and they feel as if, okay, they're then charged a second time, a third time. And each time they're getting bail very quickly. So when we return,
Yes.
I want us to really look at it. Is this these proposed amendments, are they going to tie the judge's hands in saying, if breach comes to my attention by way of a note to the police or by whichever
To the
means,
court.
I don't know, to the court learns of it, I must call you in and then take away your liberty. Very, very serious. When we return, you're watching The Legal Brief.
Welcome to a world of art, a world of entertainment, and a kaleidoscope of cultural expression. It's a new season of A&E Showcase. Allow us to take you on a journey and introduce you to the talented artists, musicians, and creatives who share their incredible stories. A&E Showcase.
My learned friends, as we get into this, and you know, I always find it so refreshing when, as colleagues, we get together and we go through these new amendments. We go through the law. It's such a beautiful thing. And even though people get up in arms about it, I just think it's wonderful. I just love it, particularly great minds around the table. So getting right into this, the amendment. When we talk about the shall, and we look at, this would be the insertion of 9A, and then we're looking at 9A5. We talk about the recognizance of bail shall be conditioned. And for those who are listening in, that's important because in law, we have certain terms. Something shall, something may. When we say shall, mandatory. Meaning the legislature is firm, they want this to be followed. May opens up discretion. So it says shall. So the recognizance of bail shall be conditioned that the accused person, meaning the defendant, duly appear at the time and place of trial or of an adjourned hearing and not depart the court without leave. So very important now.
time and date is specific.
So we have instances when you've been arraigned before, let's say the Supreme Court, you're on bail for an offensive murder. From time to time, we call it case management. You're summoned to court. Your case is being case managed. My mind, I'm understanding here is you, the defendant, must be at that court on the date and the time. Court is at 10. Be there when your name is called. You must be at the place and at the time when your case is called.
Yes.
This is what I'm understanding. Because again, we
Cannot forget their dates.
no, we
The
hear it a
defendant
lot,
cannot forget
particularly
their
as
dates.
defense counsels, and obviously you would as
Yes,
well
yes.
from the direct
DPP's office.
DPP's office. I always think the Crown, so I have to
Yes,
get used to
yes.
DPP's office. But because you always hear defendants say, "Oh, I forgot my date. It was so long," or the time I missed the bus. I couldn't get a ride. Oh no, it is saying, listen, shall. Because if I'm understanding, if you're not there at that time and place, your bail shall be
Revoked.
revoked.
Yeah.
Also, it says adjourned hearing, just as important
Case
as let's say
management.
case management, you need to be there. And two, you're not to leave the court until the judge dismisses you, tells you, John Doe, you're now excused. Your court is now adjourned to such and such a day. Until you hear that, you be there.
Yes.
That's, yeah, they're tightening up.
It's a serious onus
Yes.
on the defendants.
Very, very important. And bearing in mind as well, you can't now point the finger, oh, my counsel didn't tell me the time. And I was sitting outside for the longest. And so I just left because I had to go to work or this. Those excuses are now out the window.
If you want your liberty, you follow the rules.
Yes, shall. Date and time, you be to court. Then B, that the accused person not interfere with witnesses.
Yes.
Now,
The onus is on the Crown to show that this accused person has interfered with the Crown's witnesses.
I
that-
smile because,
There are some difficulties, but
yeah,
what I do as a prosecutor, I do affidavits of fair because we have a duty to prove. Whether
not
by way of witness-
suspicion,
No,
but putting forth
Yes.
cogent. Because
Yes.
sometimes you hear,
But-
oh, this person is calling me and they're just breathing on the phone.
yes.
You know that that's
No.
the accused.
Well, if the witness says that this person came by my home and threatened to kill me.
Well, that's different.
yes,
That's
yes,
different.
yes.
I
So-
see the person
yes.
or even an associate
Yes,
of.
an associate is correct.
That's different.
Yeah.
But if you're talking about, breathing on the phone, or you happen to be out somewhere and you said, he was looking at me. I mean, come on now.
I always take the view there's no property in a witness,
No.
right? But you draw the line when that witness, as a result of something you say or does, apprehends fear.
Yes.
Then you could see the distinction there.
And then too as well, we can understand because again, all of this is happening. Bail
Yes.
is at its very essence,
It
and
is
these
all the
conditions
time.
is that the legislature wants to ensure that the process goes through as smoothly as possible.
Yes.
That you're charged, you show up to court on time, you're present each and every time, and so that the cases can go on. And of course, you're not intimidating witnesses
Yes.
or trying to influence them in any which way so that they don't testify against you or come and change.
But I've had a witness that allegedly died last year. In some
Well,
strange
COVID is
circumstances.
going around.
No, but this was in July last year, in strange circumstances, and so on a family island, and so we have those instances where certain things are not unexplainable, and we are concerned.
And it
about
makes
the
your mind
witnesses'
wonder.
protection.
And
Yes.
wonder, unfortunately, in the
Yes.
direction of our clients, Mr. Rule.
Look
Well,
at
so
see.
we have to have evidence, obviously.
Yes.
But
Yeah.
it's unfortunate
Yeah.
that it has gone to such an extent where persons we have to have anonymous witnesses. Those people, they would give give a statement and then they would not give the names.
That's for another topic.
Yes, I know.
Another time.
I know.
Because I don't like it. I do not. I
Yes.
think it's so unconstitutional.
Yeah, I know.
If you say I did something, face me.
Mhm.
Stand in that box, face me, and say it to my face.
Yes.
And let me be able to question you. I'm sorry. I just feel,
Yeah.
particularly when you're talking about very serious offenses.
Have a look at C.
C, and this is what we were discussing during the break, that the accused person not commit any offense while on bail. So I want both of you now to chime in on this. We're hearing, and we don't discuss this in a vacuum because we're hearing, and the fear is that defendants who are already on bail are committing other offenses and that they're receiving bail in some instances 2-3 times. The commissioner of police have
One
said
of them
this.
said 6 times.
Yeah, so they're saying, and he seems to be incensed by it all, not just him, but others as well, and saying that this is outrageous to general public. Now, for me, I read this a particular way. Is this saying that if I am on bail and I am charged again with another offense, that my bail shall be revoked? Is that what this is saying? If I am charged with another offense, that automatically my bail shall be revoked, Mr. Rule?
Let me tell you what my difficulty is with this.
Mm-hmm.
5 does say shall, as opposed to 6, which says may with respect to conditions.
Mhm.
But when you look at the object and the reasons, it says under
It's on page 7.
page 7, it says under A2, to provide for the revocation of bail on the conviction of an offense under section 12A for breach of the conditions of bail. But when you look at 5C, it doesn't say that. It doesn't say that. What 5C is telling me is, I go there, police charge me, whether I did it or not, that's a different story, because they have to prove that. The police charge me, I could be sent back to prison. I say less.
I don't know. I don't know. And it seems as if our time is just flying. I need to hear from you.
Yes.
I know. Come on, 1 minute. What do you
Yes.
think?
I would say that the person perhaps be convicted. And
They should be convicted.
So it's a
offense.
conviction.
No, they should be convicted.
It has to perhaps be redrafted, I would say.
Yes.
Yes, more
It
clearly.
has to be.
Yeah, more clearly, yes. In order, yes, more clearly, yes.
It has to be
Yes.
a conviction. It certainly cannot be that we are saying that if someone, again, is just accused and then charged again by the police, that their bail will be revoked. Because again, that can be abused. And that can be abused easily.
Yes.
And to my mind, that's an abuse.
It throws my constitutional presumption out the window.
Yes, certainly does.
Yeah.
So I'm happy that both of you agree with me that this has to mean a conviction. Because the plain wording is
But wouldn't that be, if it means a conviction, wouldn't that then be not so onerous on the defendant? Because then he would have to have a conviction
Yes.
and not just be
not
charged.
to be charged.
Yes.
And
So in essence, then I do not see why there is difficulty, because he would have to be convicted of another
Yes.
offense.
And so therefore, so it still in my mind does not answer the concern
Mhm.
that is being placed forth. Because people are saying their concern is they don't want persons out on bail who have 2, 3, 4 charges pending. That's in essence what they're saying. I don't want you out on bail and you have all of these charges pending. I want you locked up.
Well, once they breach their conditions, even without, this is how I read it,
Yes.
even without, this is severally now, even without the conviction, once they breach a condition of the bail,
Not
uh,
show up on
not
time.
show up on time, interfere with the witnesses and all of that.
Well, it's only those 3 that
sorry,
are shall.
The shall, okay.
Yes, only those 3.
But in any event, once they breach the conditions, then the court still has the discretion, the Supreme Court that is,
Yes.
whether or not to revoke their bail.
But not if you're just simply charged.
Yes.
And I think that, and so that to my mind makes me wonder, is this really necessary? Because it still does not answer what the general public or what I'm hearing from certain powers that be, what their problem is. Their problem is, I don't want someone out who has 3 or 4 charges. But constitutionally, you can't lock up a person just because they have 3 to 4 charges.
I think the Attorney General has recognized that, the Minister of National Security has recognized it, and I also believe that the Prime Minister is very well aware of that. But I believe that this was put out into the public to start the discussion in order to get us where we need to
You
go.
want to tell me you put all of this bail amendment bill out just to start a discussion?
Well, in order to get us where we need to be.
I know the PM as well.
Yes.
So I know this will be fixed.
Yes. By the grace of God.
Very interesting. Very interesting.
Think about it.
Yes.
Sheila.
A lot to think about. A lot to think about. When we return, you're watching The Legal Brief. I'm your host, Ramona Farquharson.
You're not going to do very well in this court if you keep cutting me off.
I've already paid him $500, and I noticed we haven't spoken about the $500 that I paid him. I did not receive any of my money.
I didn't know her like that.
I ask a question and then you answer.
But I spent
And
that on my car.
Mr. Roll, that is the order.
I joined an ASU that was led by Mr. Wilkinson. At the end of it, I would have received $5,000. However, I did not receive any of my money.
You would understand the importance of a wedding day for a bride.
Well, I've never been a bride.
The decision is legally binding.
All right.
My learned friends, this episode has been so interesting and illuminating, particularly getting into this new proposed legislation as well. I want to find out from you just very briefly, because we spent so much time discussing this area of bail. I want to find out from you, do you believe that an amendment is necessary to the Bail Act, that we should have an amendment? And if so, should it be what's presently before us, or should we be going in another direction? I'm going to start off with you.
Well,
Ms.
the Prime
Dorsey.
Minister is firmly of the view that we need this amendment due to the outcry of the Bahamian society in relation to so many matters that they are concerned about concerning bail being granted to persons who have multiple murders allegedly under their belts, or at least have been charged with multiple murders or offenses. And because of the outcry of society, I would say that the new Bail Amendment Act, it is needed, but I think perhaps more time is needed in order to make it more in line with the constitutional provisions, if at all we can that we can reach that middle ground, if that can be done. Yes.
Mr. Roll?
Personally, speaking for myself, I think we just need a more caring and compassionate society, for starters. I agree with Ms. Dorset. I believe the PM has all good intentions, and I believe that he will do well. We need to work with him. In terms of the amendments themselves, defendants need to be more responsible. We need to almost find it a privilege to be on bail and to abide by the conditions of bail. The amendments are very stringent. The intended amendments are very stringent, and it will not only affect me, a defendant, but it will affect the persons who sign my bail. And it's really going to make the suretors really consider whether or not you are a suitable person, in their view, to sign the bail. And so with some redrafting, some more conversations, I suspect we will get a bill that is workable, is practical, and
But you don't think this is it?
not in its current state.
No, you still think it needs some work?
It needs some work. That's my 2 cents. Oh, sorry, we don't use cents anymore. That's my nickel.
worth a lot more than that.
Yes.
I opened with saying bail, 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 oh bail, because it's so reminiscent of when my grandmother used to call my name when I was in trouble, when things were dire. And unfortunately, we find ourselves as a society in a very dire situation. Crime is increasing, very serious crimes, in particular murders, are increasing at an alarming rate. And so here it is. We have our legislature grappling, trying to put together strategies to tackle, because it's a problem and we need to deal with it. Is this the answer? The Bail Amendment Bill of 2024? I believe it does have some good. I believe a lot more needs to be done. In particular, it appears to me that the issue is that society feels that persons who are on bail are reoffending. And when they say reoffending, they feel as if they are racking up other charges. And so if you have another charge or 2 or 3, some instances they say 6, there's a feeling that you ought not to be granted bail. The question is, can that be done? Can that be legislated? Having regard to something that is also very important and that exists, and that would be the Constitution. You are innocent until proven guilty. And so, albeit you may be suspected and charged of a number of offenses, that in and of itself is not sufficient for you or for any court to say that you are not a fit and proper person to be granted bail. That's the dilemma. How will it be solved? Does it even matter? We don't know. It's a matter for you. We've given you as much as we can the information based on what's before us, the law. For you. Thank you so much for watching. This is The Legal Brief. I'm your host, Ramona Farquharson, and you're watching ZNS TV 13. For watching The Legal Brief, be sure to like, comment, or subscribe for more.